Good afternoon, class. Hello, can you hear me?
We can hear you, sir. Good afternoon.
Good afternoon and welcome to today's class. My apologies for joining you a bit late. We would like to continue from where we stopped last class. And just for the sake of clarity, the classes we have for Wednesday by 11 a.m. and Thursday 3:30 p.m. is for the Nigerian legal system, that is 200 level law students. Yet I authorize that the 100 level students for mass communication and the ICE student 100 level and direct entry for mass communication who can also join. And the purpose is to give them an advantage because it's the same course content, except for some two topics that are different. So the idea is that you will take advantage of listening to this lecture twice. So every lecture for Wednesday 3 a.m. and Thursday 3:30 is the 100 level direct entry student of Faculty of Law, and the one for 5 p.m. Wednesday evening is for the ICE students 100 level, and then on Friday by 11 is for the regular. So that's just for the purpose of clarity for mass comm students that are with us. The law students do not have any issue because they maintain their regular time, and then they don't really need
Dr. Saja, you mute your video.
classes. So I believe we are clear now because somebody raised that question when I was addressing the IC student yesterday. So welcome to today's class. Yesterday on our last class, our focus was on customary law as a source of Nigerian law, and we dealt with that extensively by looking at everything that surrounds the subjects of customary law as a source of Nigerian law. And then we looked at the validity test that a custom must pass before it can become a law.
Dr. Saja.
We concluded by looking at cases that summon or that gives clarity to the points that we made in the course of that class. But it's better that I allow you to do a review of what we did in that class. I believe it will give us some kind of understanding if our mate is giving a recap. So I will make the floor open for anyone who will want to do us a favor of giving us a recap of our last class for just to refresh our memory. Is anyone there? Anybody? Okay.
Good afternoon, sir.
Yes, good afternoon. You can go ahead.
Okay, so we talked about customary law
in the last class, and we said that there are customs and traditions that are abhorrent or disgusting or barbaric, which cannot be considered as law, so as to ensure that those kind of laws and all those kind of customary laws from different places that we may be from are not allowed. So there must be a validity law test that must be passed down before any law, before any custom can become a law. So that's what we talked about. And the validity tests are three: is the repugnant test, the compatibility test, and the public policy test. So that's what we talked about, sir.
Okay, thank you very much for your contribution. Do we have, because I think we still have some things untouched, even though the speaker tried. Okay, who else is speaking to us? Deborah Olatunji, go ahead.
Okay, sir. We talked about the validity test, and as she already mentioned, there are three. So I'm just going to summarize what we talked about then. Then the repugnancy test, it requires that customs should not be repulsive, that they should.
Deborah, we lost you. Are you back? Okay. Let's Collins take on, pending when she's back.
Good afternoon, sir.
Good afternoon.
So yesterday we talked about customary law. In particular, we talked about the validity test, and the validity test really, you talked about that. It is not every custom of a particular ethnic group in Nigeria that is regarded as.
Sorry, go ahead, Collins. On mute, please.
Can you hear me now?
Yes, please.
So, in order to explain the validity test and the reason for why we have it, we are trying to explain that it's not every particular ethnic group in Nigeria that is regarded as that is considered as a customary law. That this creates an attempt to expand on this subject matter. That for every customary custom to be recognized as customary law, they must go through the validity test. And it is the validity test is an established rules and yardstick that is put in place to determine customs that will be regarded as laws. And you also said that we should know that Nigerian customary laws, some of which are partly considered and abhorrent. So you asked the class to contribute some of those customary law from their parts of the country that they consider to be abhorrent or repugnant. And some people named female genital mutilation, and some people named ethnic group. That like somebody from River State talked about cannibalism. That there are some people in River State that practice cannibalism. And he also another person talked about the practice of a woman who is made to drink water used to bathe her dead husband, which is according to the rationale, it is to prove her innocent that she did not kill her husband. So he also talked about practice of child marriage and practice of somebody talked about the in Yoruba land, some place in Yoruba land where before the new Oba can become the Oba, he has to eat the heart of the dead Oba. So you talked about the history of customary law. I talked about that since colonial times, they can be found like in there are some laws that can be found in the high court rules of each state and even the capital territory. That until recently there was a practice of disinheritance of female children. So you talked about you listed the validity test to be three, which is the repugnancy test, the compatibility test, and the public policy test. And trying to explain the repugnancy test, you talked about the fact that it requires that a custom should not be repugnant. That is, okay, repugnancy test talked about a custom that should not be repugnant. That is disgusting and repulsive to natural justice. Where a custom is said to be repugnant to the rules of equity, the court is enjoined to ignore and not apply such customs. And you went on to define what is natural justice, that this concept varies from society to society. And you also talked about you gave us some cases that we should read concerning this issue. Like you named the case of Damole versus Dawudu, which related to the natural justice and equity and good conscience. That is sharing of property of a disease of a deceased. So you talked about the fact that okay, in this case, there was the plaintiff came to court and he talked about the fact that okay, being that the man died intestate, they should share the property through the EDG system. The defendant responded by saying that the property should be shared by the Ori-Ojori system. So the trial court held in favor of the defendant. No, the trial court held in favor of the plaintiff that the property should be shared through the EDG customary sharing system. Why when the defendant appealed, the appeal court held in favor of the defendant by sharing the property through the Ori-Ojori system. He also gave us the case of Salako and others versus Salako, and okay, and explaining the compatibility test, you talk about you said that it means that these customs must not be incompatible with any law that is enforced in Nigeria. Like you talk about the rule that a female child cannot inherit the property of her father. That this should not apply because it is in contrast with the Constitution of Nigeria, per section 42 of the 1999 Constitution. And also you talked about the public policy test, which is said according to Malemi, by defining it according to what Malemi said about public policy, that public policy on its own is very difficult to define, and that it can mean public welfare, public good, and interest. That any public policy found to be wanting in any way, that any public policy found to be wanting in any way to assert the public policy. Sorry, I think I didn't get that part correctly, but that is what I was able to get. And you also gave the definition by J. Jordan, which that public policy as ideas which prevail in our community at the material time as to the conditions which are necessary to ensure welfare. You gave the case of Cole versus Akinleye, which talked about children, like a child that is born outside wedlock, about the fact that okay, the fact that a child is born outside the wedlock and natural, according to the policy of sorry, sir, I think that is
all right. Yeah, I think you've tried. You did well. Thank you very much. Oshinuga, let's take Oshinuga, then we take on from there. At least it shows your level of understanding of what we did. Yes, Oshinuga.
Good afternoon, sir.
Good afternoon.
So, sir, we talked about customary law. We talked about the validity test, and you said that it is not every custom that is regarded as a law. And for every custom to be called a law, it must pass the validity test. And he said validity tests are the established rules that are put in place to determine custom, which will be regarded as law. And he also went on to say that there are three validity tests, which are the test of the repugnancy test, that it must not be repugnant to natural justice, equity, and good conscience. The compatibility test, that it must not be incompatible with any written law or legislation. And he also said the public policy test, that is not contrary to public policy. So he went on to say that the pregnancy test, that it is it's that repugnancy, it must be required that a custom must not be repugnant, that it must not be repulsive, and it must not be disgusting. And he also gave us the case of Damole versus Dawudu. That is, they're talking about how the inheritance of a deceased man will be shared after his death. That um per capita talks about the Ori Ojori, that is by the number of children born by the wives, while per stripe talks about Idi Igi inheritance shared based on the numbers of wives. And we also went on to talk about the compat compat
Stability.
compatibility test.
Yes.
Compatibility test, that it means the custom which must not be incompatible with any written law that is in force, that it must align as a matter of fact and not be in competition and inconsistent with the law that is in force. I also went on to say that according to AJ Malibi, that said, oh, sorry, sir, I mean public policy, sorry. Went on to say that public policy test. He said, according to J.A. Malibu, that he said public policy is quite difficult to define, but it means the public welfare, public good, and public interest. That some
Well, that's another good attempt. Thank you very much. One good thing about the exercise of this recap is that the likes of Shunuga, likes of Collins, and the other people that spoke earlier will not forget easily what they have shared with this class. So if you want to know, you know, uh, more about what they are teaching you, one of the ways to do that is to participate actively. Participate actively, no matter how small. And again, your view is your view. And in this class, and for the purpose of this class, there is no answer that is a foolish answer. Every answer here is welcome. And when you make mistakes, we'll correct you. As a matter of fact, that is the reason why you are here. If you are perfect, you'll probably not be here. So I encourage as many as possible to participate in this class. The question and answer option, I think, is open. You can engage that if you need to ask questions. All right, so we'll take it off from there. And with that summary, I am satisfied that we have dealt with customary law as a source of Nigerian law. Now, before I move out of that point, it is important that I discuss briefly on proof of customary law. Proof of customary law. Now, we made mention of the fact that, yes, a custom must satisfy or must pass through all of those tests before it can become a law. Yet now that it is a law, how do you prove the law? That is one aspect that I will talk about briefly, and then we move on into other things for today. And the proof simply talks about how to establish customary law, which is also the same thing as proof of customary law. Now, there are two basic methods of establishing customary law before the courts. For those of you with Nigerian legal system by Obilade, Akintude Obilade, you will see that in your textbooks that the learned author said that there are two methods of establishing customary law before the court, which includes one, by proof, and also by judicial notice. And when we're talking about establishing customary law by proof, we talk about the proof before courts other than customary and area courts. What that means is that we may want to establish, if you have a duty to establish customary law before a court that is not a customary court, there are some requirements that you need to satisfy. And then, of course, even though the Nigerian Constitution does not, in some ways, take customary law as a law that should have some general application, yet it applies to various aspects of our lives, and that is why we cannot, disregard or discard the law as some of the laws that affects that affect us as a people. Now, going by what Obilade said, in looking at section 14 sub 1 of each of the I'm trying to confirm that of Evidence Act, section 14, he said a custom may be adopted as part of the law governing a particular set of circumstances if it can be noticed judicially or can be proved to exist by evidence. And the burden of proving a custom shall lie upon the person that is alleging is existence. So what that means is that if you need to establish or prove a custom, there is need to do that by showing of evidence. And evidence, of course, is defined as anything that gives reason to believe that something exists. Okay, that is evidence, and that is more like defining evidence in a general sense. You say, okay, what is the evidence that you are a mother? You bring your child. That is sufficient evidence that you are a mother. So what we are saying is that if you must prove or establish a custom, you have to do it by giving evidence of the fact that it exists. And of course, this is usually done by practice because maybe it has been applied sometime within a community over and over. Then, consequently, an individual who is in court to establish such a custom can make reference to such cases more like as it applies to judicial precedent or case law, to say, oh, this court, even though customary court has ruled on this custom before, and then it has become noticed to the point that it's more like becoming a recurring factor. So you can prove or establish customary law by showing evidence that that custom exist. Taiwo is raising her hand. Do you have something to say?
Good evening, sir.
Yeah, good evening.
Sir, please, can you go over section 14 of the Evidence Act? I didn't get what you said.
Yeah, it has contained in the book Nigerian Legal System by Obilade. Let me repeat what is written there. I'm sure that even though the section must have changed in the current Evidence Act, but I mean maybe the section must have changed, but the content will still remain the same. So the Evidence Act section 14 sub 1 says that a custom may be adopted as part of the law governing a particular set of circumstances if it is noticed judicially or can be proved to exist by evidence. That is by showing of evidence. And the duty to prove a particular evidence lies on the individual who is alleging that that particular custom exists. So by showing that, yes, this is what is obtainable in the society, as a matter of fact, it has been applied in different ways, then the court may be deemed to see that such a custom indeed exists. And there is a part of the submission made by the learned author, Akitunde Obilade. He said, and I quote, he said, a party to an action cannot succeed by merely proving the existence of a custom which he relies on. He went further to say that in order to succeed, he must prove its existence in relation to a particular set of circumstances. In other words, he must prove that the existing custom govern a situation, maybe marriage, maybe chieftaincy title, maybe inheritance, and so on and so forth. But all of that still boils down to the fact that you will show evidence that the law exists or that the custom exists, and it has been used over time to adjudicate within the legal system, whether within the customary legal system or whichever way we address it. So that is one way of proving it by evidence, by showing evidence. The second one, quickly, which I will point out, is that it is judicial notice. That is, the custom has become so notorious that the court now knows that this system exists, or this custom does exist. Now, I'm still referring to the Nigerian legal system by Obilade here, and I want to read what is said in my own page 93, under judicial notice. He said, and I quote, certain facts are so obvious that they need not be proved before the courts. For example, it is not necessary to prove that human beings have hands, or that water is a liquid, or that horses are animals. There are some things that you don't need any serious proof to establish that they exist. Just like when you see a man, when you see someone, the features on his body will probably show that this is a man. You hardly, okay, just maybe very few men will plait their hair. Most men will leave their hair, whether in this form that I carry, or we cut it so low, and majority of men are like that. And then men have their own special way of dressing, even though some female like to dress like male. But the point we are making is that there are some things that are so obvious. And how can a custom become so obvious? A custom can only become obvious or become popular by usage. Okay? So that is his submission. He said such fact, that is that water is liquid, or that human beings have hands, or that horses are animals. He said such facts are said to be judicially noticed by the courts. Okay? So that is another way to prove customary or a custom. For better understanding or deeper understanding, you can look at that particular textbook, and then you will get the understanding that we want you to have. So quickly, we move into Islamic law as a source of Nigerian law. Mind you, we are looking at topic 3 of this course, Nigerian legal system, which others are known to be Introduction to Law and Nigerian legal system. And just by way of clarity, the first topic we looked at in this course was the concept of legal system, which followed by topic 2, historical development of Nigerian legal system. And now we're in topic 3, which is sources of Nigerian law. And under the sources of Nigerian law, we have looked at Nigerian legislation, we have looked at received English law, we have looked at case law, we have looked at customary law, and now we want to look at Islamic law. So, by way of introduction, Islamic law is also known as Sharia or Sharia law. And one other thing that we have said about other sources of law is also applicable in this sense that, Islamic law is another important source of law in Nigeria, especially in the northern states, where it is applied or it applies to Muslims in maybe in personal, maybe family, and even some matters that relate to crime. Even though very recently we understand that whether the Nigerian system is trying to introduce, or whether it has been introduced already, Sharia law in the southern part. Maybe I think I saw that news flash in Oyo and some other states. But of course, that is just by the wayside. But the point we are making is that this law is one other important aspect or sources of Nigerian law, especially in the northern part of Nigeria. It governs personal life, it governs issues relating to family, it sometimes governs some aspects of criminal law. And then Islamic law is derived from the Quran. Okay? It's derived from the Quran. That is one. It derived also from what is known as hadith. H-A-D-I-T-H. Our Muslim brothers, we may have a different pronunciation for it, but just take that pronunciation for the purpose of this class. So Islamic law is derived from Quran, from hadith, which simply means saying of Prophet Muhammad. That is, one of the sources of Islamic law. Deborah Olatunji, You have a question?
Sorry, sir. Can you please spell the hadith again? Or hadith?
You get that?
No, sir. I think your mic was muted.
Okay, Hadith. Hope you got it now.
Yes, sir. Thank you, sir.
Okay, so it's gotten from Quran. Islamic law is gotten from Quran, Hadith, which also means the sayings of the Prophet Muhammad. Another place where Islamic law is also derived from is what is known as ijma, spelled as IJMA, ijma. Ijma is also known as consensus of scholars, which of course we can simplify by saying the opinion of scholars, or that is Islamic scholars anyway, because those of other religion will not have so much submission, valid submission on the subject of Islamic law. So apart from ijma, it is also gotten from qiyas. Qiyas is spelled Qiyas. So far so good. We have established that Islamic law is also known as Sharia law, and that is an important source of Nigerian law, which is applied or mostly applicable in the northern parts of Nigeria, and that the Islamic law is derived from Quran, Hadith, Ijma, and Qiyas. Now, this Islamic law as a source of Nigerian law has unique characteristics which we want to look at. Okay? It has some unique characteristics which we have to look at. Yes, someone is raising a hand. I think.
Excuse me, sir.
Yes, please go
Please,
ahead.
can you help me to spell the Korea again? Korea.
I didn't say Korea. I said Queers. I don't know what you remember.
Can you please spell
It's
it, sir?
pronounced Kias.
Kias.
Yes.
Okay.
Oh,
We have a scholar in the house who has said it's Kias.
thank you, sir.
Qiyas.
I've gotten that, sir. Thank you, sir.
Okay, how is the other one pronounced? Hadith, Ijma. Can you tell us the pronunciation?
The first source is Quran. The second one is Hadith.
Hadith.
The third one is Ijma.
Ijma.
Yeah.
Why the last is Qiyas.
Exactly.
All right, thank you very much. So Qiyas means analogical reasonings. Okay? So those are the sources of where Islamic law is derived from. So let's quickly look at the essential characteristics of the Islamic law as a source of Nigerian law. Number one is that it governs basically the lives of Muslims, meaning in a way is a religious law. Okay? It governs mainly the lives of Muslims, meaning it is a religious law. Mind you, even some scholars believe that Islamic law is a customary law. But personally, I do not want to share that view. But of course, all of us were entitled to our opinion, as far as it helps to develop our jurisprudence. So the first essential characteristics is that it is a religious law because it governs mostly, basically, the lives of Muslims. Number two is that it regulates the Muslims' interaction with non-Muslims. It regulates the Muslims' interaction with non-Muslims. Another essential characteristics of Islamic law is that it preaches against man-made laws and gave divine-made laws as alternative. Okay? Islamic law sees man-made law, it preaches against it and supports divine law in its stead. Of course, maybe because from the angle of the fact that divine law is a perfect law, which, of course, are applicable to everyone without any form of discrimination. Okay, so that is for that. Then also, another characteristics is that there is an explicit emphasis that Allah is the lawmaker. That is, Islamic law is made by Allah. There is that emphasis, and that's one of the characteristics of Islamic law. So they believe that Allah is the lawgiver and that, Muslims are just a trustee of this law as a source of Nigerian law. Yes, or now, you have a question?
Yes, please. What did you say? You said, please, can you repeat this point again? You said that Allah is what, please?
That Allah is seen as the lawgiver. That it is this Allah that gives this law, and that Muslims are just trustees, meaning that the Islamic law is not made by Muslims, that it is made by Allah. That is one of the major characteristics that have been attributed to Islamic law as a source of Nigerian law. Now, it is important that we look at customary law and Islamic law side by side because of the fact that they share some form of characteristics together. And of course, the two systems are not the same, and that's why we will not classify Islamic law as customary law. And the reason is because it was the colonial masters in an attempt to unify Nigerian law that classify Islamic law as a customary law. And that was done by virtue of Section 2 of the Native Court Ordinance of 1914. So by Section 2 of the Ordinance of Court Ordinance of 1914, the colonial masters, classify customary law as Islamic law. But in the real sense of it, Islamic law is a distinct law on its own. Collins, you have a question?
Yes, sir.
Okay, right.
You said that Islamic law is not customary law. So if Islamic law is not customary law, then the northern part of Nigeria, which law is their customary law if it's not Islamic law?
You see, one thing you must note, if you followed us when we were dealing with customary law, or when we were talking about the features of the Nigerian legal system, we did say that as a people, we have more than 250 ethnic groups. Those maybe part of that 250 ethnic groups are also situated in the northern part of the country, meaning that even there are communities that they are a unique ethnic group on their own, and they have their own unique law. Customary law, they have their own customary law, they have their own custom. They also have in existence Islamic law that govern their own aspects, some part of their lives. So Islamic law is not what applies to or that covers all. Each ethnic group or nationality still have their own unique laws, customary laws, so to speak. Okay? I hope I was able to answer your question. So I said that Islamic law, I still maintain that Islamic law is not customary law. That what led to the classification by some scholar is the fact that our colonial masters, by virtue of Section 2 of the Native Court Ordinance of 1914, classify Islamic law as a customary law. What other second reason can we give? Now, the other second reason that can be given is that Section 2 of the old Native Court Law of the Northern Region, number 6 of 1956, refers to Islamic law as customary law. And then they use the word native law and custom. So that makes Islamic law to be treated as indigenous customary law. Of course, like we said, Quran, Qiyas, Ijma, and all of that are not customary law. They are not derived from custom. Why the Quran, of course, which is the holy book for Islam, Hadith are the sayings of the Prophet. Ijma refer to consensus of Islamic scholars, and Qiyas as analogical reasoning deducted from Islamic practices. So that's number one reason why we say it's not, or why people refer to it, because the colonial master tried to classify it as one. The second one is that there was an erroneous reference to Islamic law as native law and custom, and that was by virtue of Section 2 of the old Native Court Law of the Northern Region, known as number 6 of 1956. So that is another reason why Islamic law is often referred to as customary law, but as we noted in this class, they are not the same. Joy Adenekun, you have a question?
Oh, sorry, sir. I wanted to ask the second point you said. So you said it, sir. Thank you, sir.
Okay, all right. So Islamic law and customary law runs in different channels. Okay? So consequently, like we said earlier, one is religious and the other one has to do with tradition or custom. So And also another major feature about this that we also need to note is that it is also observed that one is more rigid than the other. Islamic law is, because it's written, enjoys that feature of rigidity, while customary law is not in any way frozen or cast in stone. It is flexible. That was one of the major features of customary law that we discussed, that it is flexible. So Islamic law is rigid because it is written, and it's not just a way to describe Islamic law, but to say that by virtue of the fact that it is written, largely written, it is difficult for anybody to change it. Okay? So that is another one. So Islamic law is more rigid, unlike the indigenous customary law, and it is very flexible. Now, let me refer you to the case of Akamawa versus Hassan Bello and another. Akamawa is spelled Alkamawa versus Hassan Bello and another. In that case, the court held that Islamic law is not the same as customary law, as it does not belong to any particular tribe. And that is why, to refer to the question that is it Collins now somebody asked not too long ago, Islamic law or Islamic practices, they're almost like the same all over. And that's what necessitated the reasoning by the court when the court said that Islamic law is not the same as customary law, as it does not belong to any particular tribe. You can say the custom of what's a popular custom in Yoruba land, for example, maybe the New Yam Festival, for example. The New Yam Festival is known to some indigenous people in Nigeria. In my place, there's a certain part of the year that you cannot bring out new yam. Meaning that if you plant your yam and your yam matures before, whether the 7th month, I can't remember now. If you have to carry it, you have to hide it. You cannot carry it in the open until they celebrate that festival. Before you can now carry it in the open. That particular custom is peculiar to my place and some other places where they practice such, meaning that it's not general. When maybe very soon now, the Muslim will start their fasting, and then there will be a time where they will conclude the fasting and there will be some form of celebration. It is done practically all over, not a particular ethnic group that is doing it. So that case buttresses the fact that Islamic law is not a customary law because it does not belong to a particular tribe. Okay? While on the other hand, customary law differs from tribe to tribe, from community to community, and society to society. In some society, if you plant your yam and then it matures at maybe any time of the year, you are free to carry it and eat it. You are even free to carry it to the market and sell. That is custom for you as against Islamic law that is more unified. It's a unified system. Okay? So, having said that, let's also look at other aspects of Islamic law. Now, Islamic law, like I said earlier, governs matters such as marriage. That is when it's seen as a personal law. If Islamic law is seen as a personal law, it governs aspects such as marriage, divorce, inheritance, which can also be called endowment for Muslims. And then the Marriage Act does not apply to marriages conducted under Islamic law. That is where Islamic law is applied in personal matter, which we cannot refer to as personal law. And that's why anybody who got married under the Islamic rite, his marriage is not subject to the Marriage Act. For example, the Marriage Act recognizes a monogamous family, meaning that when you are married under the Act, the Marriage Act, you cannot go and conduct another marriage when that marriage is subsisting. If you do that, you'll be committing an offense known as bigamy. But as a Muslim, who is married under Islamic law, I think I understand that you can marry as much as you have capacity to care for. So probably it's a matter of capacity. If you have capacity to feed, to take care of 10 or 15 as the case may be, so be it. You have the financial capacity, you have the human strength, you are allowed. And then,
Sir,
am I
sir,
wrong with that submission? Yes, Tijani?
the maximum
Yes, sir, the maximum is 4.
Is 4.
yes, sir.
Yes, sir, if you have the capacity.
If you have
And if not, just 1.
Okay, let me hear from you now. What kind of capacity are we looking at?
If you can cater for them,
Catering in terms of food or what else?
like if you can cater for their well-being, everything. But if you can't, if you can't be just between them, then just 1.
Okay. Now, if you say that, can you please mute? You have two devices with you. So how do you? But the law does not punish those that marry like 5, 6, 7. What do you say about that?
I would say they are not strictly following the rules in that case.
They are not following the Islamic.
Yes, sir.
Oh, okay. All right. So the faithful Muslims are only allowed to marry 4, right?
Yes, up to 4 is in the Quran.
Okay.
And if you know you can't be just, then just 1.
Just 1. Which
Yes.
what number are you in the marriage? Which the 3rd?
No.
Okay, you are here to join. All right. Tijani wants to say something. Or Tajuddin, sorry.
No, I just wanted to say, contribute to what she said.
Oh.
It has its own limits. Like, if the wife, for example, if the wife is not like, doesn't have any ailments or anything, there are limitations to it actually. There are limitations to before you can marry up to that 4. So it's not that I married this one, she has given birth, she has everything I said and marry another person. It's not like that. It has some other what's it called before you can marry.
Okay. All right. Jennifer, the fine girl that was advertising herself yesterday.
It was an accident, sir. Sir, please, I don't have a question. Sir, my device is about to die. Can I please put my attendance down?
So you are disrupting this class because of attendance.
I'm sorry, sir. It's gonna die.
So we continue. If we look at Islamic law as it applies to personal law, it takes care of issues of marriage, of divorce, inheritance, and endowment. Then we're saying that Islamic law is not subject to, marriages under Islamic law is not subject to Marriage Act. Then Islamic law is administered through Sharia court of first instance. Okay, we have the Sharia court, we have the upper Sharia court, we also have Sharia court of appeal, even in some northern states. So what it means is that the application of Sharia law or the administration of Sharia law takes place at the Sharia court. Then some states, when we want to talk about Islamic criminal law, some northern states such as Kano, Zamfara, Sokoto, and so on have expanded Sharia to include to include criminal law. That is, they also use it to attend to needs that pertains to crime, even though the Constitution of the Federal Republic of Nigeria has revoked the power to try crime under customary law. Okay? Yes, someone wants to ask a question?
Yes, sir. Yes, sir.
Yes.
Sir, please, the doctor just said that the Nigerian law will make some provisions concerning some certain aspects as in Nigeria, then the Islamic law will not like say their own aspect. Does that mean that the Islamic law in a way is above the law of Nigeria? Since they can make their own law in their own division, and the Nigerian law cannot say anything about it or cannot do anything about it, sir.
No, you are getting it wrong. I'm not saying Islamic law override. There are some aspects of our lives as ethnic, as a group of people, that our Islamic law, our customary law, takes care of. That's the same thing I'm saying here. For those who, there is no law in Nigeria now that says you must marry under the act. I don't know of any, except you can share with us. There is no law that insists that you must marry under the act. So if you choose to marry under the Islamic law, you are carried. It doesn't mean that you are violating the law, any law in Nigeria. So there's in some northern parts of this country, there are some areas where they enforce the Sharia law more than other states where they practice Islamic law. So that's the point we are trying to make. So, yes.
Sir,
So,
please a question.
yes.
So in year one second semester, there was something they taught us about like this same thing that you are talking about choice, that a person can choose which law he wants to administer that aspect of his life. But and the way the lecturer put it was that
Kenechukwu, we can't hear you.
I'm not the one asking questions. I'm not the one asking questions.
Okay. All right. So let's continue. Maybe the person will come back. All right. So I was talking
Please,
about,
sir,
yes, go ahead.
I have a question. So
Okay.
about you said that I also heard that Zamfara to also uses the Sharia law, like it's very, very how like it's very popular
Prominent
there,
there.
prominent there, sir.
Yeah, so what's your question?
So I just wanted to confirm if it's true because you
No,
only said Sokoto and Zaria.
yes, I said some northern states, Sokoto, Zamfara, Kano, they have expanded Sharia to cover some criminal aspect of life that deals with crime. So there is some in those states, they can engage punishment. They can, enforce punishment on people who go against the the Sharia law. And they have their different types of punishment that may be applicable. But whatever punishment they have must not be a contradiction to the Constitution of the Federal Republic of Nigeria, especially as it relates to fundamental human rights. Recall yesterday when we talked about this case versus one I've forgotten the name now, versus Adeja Native Authority, where it was a rule of custom that a thief caught on the highway is not allowed to defend himself. And we're saying that such a law, such a custom offends natural justice, because natural justice stands on the ground of fair hearing. So that is the case of Guri versus Adeja Native Authority. So if a customary law offends any part of the Constitution, even though it's a unique law or Sharia law, that law cannot stand. Okay? It cannot stand. So, and again, other aspect of Islamic law that we also need to look at is that it has had some kind of influence on the Nigeria legal principles. For example, we now have laws, Nigerian law on banking, Islamic banking. We now practice Islamic banking. As a matter of fact, it also extends to areas of dispute resolution. We have Islamic banking now in Nigeria. Of course, that will be governed by Islamic law. And I understand to some extent that the bank also do not engage in interest yielding businesses, or when you borrow money that you have to pay with interest or things like that. Especially their practices must align with the Islamic law that is, that is governing them. And then to say this is that this Islamic law has its own legal limitation, because it is a law that is made subject to the Constitution of the Federal Republic of Nigeria, which is the supreme law, which is the grand norm, which is the #1 law that must reign supreme in every situation. Okay? So Islamic law at all times, irrespective of this limitation, will remain a significant source of Nigerian law, particularly in personal and criminal matters for the Muslims, and other aspects that they may choose to apply it to, or that the law applies to. Okay? So let me take question from Deborah. I think somebody is raising their hand.
Sir, sorry
Yes.
to take you back, but we're talking about the differences between Islamic law and customary law. You said two things why Islamic law has been taught to be customary law. And the first one, you said something about colonial masters, that they did something or they wrote something down. I didn't really get what you said there.
They made an attempt to subsume Islamic law into customary law, to hide it into customary law by classifying it as customary law. Do you understand that now?
And you mentioned is an ordinance or an act.
Yes, I said section 2 of the Native Court Ordinance of 1914.
Okay, sir. Thank you, sir.
All right. Okay, so that's all for Islamic law as a source of Nigerian law. Do we have any question before we call it a day? So that in our next class, we will look at international law as a source of Nigerian law and
I have a question.
and legal writer. Yes, let's take your question.
Sir, we already agreed that Islamic law is not customary because because
How many of you agree?
are you hearing me, sir?
Yes, I say how many of you agree?
Sir. All of us, sir. We already agree that because Islamic law is not customary because the group practicing it, the religion doesn't belong to them. So I want to ask that. So in other countries that Islamic is actually their religion, will the law be customary? And in Nigeria, since Islamic law is not customary, so it will not be recognized in government?
Islamic law is recognized by the government. If it is not recognized, we will not have Sharia courts. We will not have Sharia court of appeal. It is recognized, but it not as customary law. And in other countries, they may choose to classify it as customary law. But by virtue of the point that we have made, we cannot holistically classify it as customary law. Do you understand?
Okay, sir. Yes, sir.
Yes,
Thank you,
Jeremiah.
Good evening, sir.
Good evening.
It's based on the classification of Islamic law as customary. Obviously, there's a judicial decision that you cannot classify Islamic law as customary law, yes. But then how do you, because you said it does not apply to every aspect of people's lives. There are some parts that cannot apply, probably because of natural, because it's repugnant to natural justice, or because it does not align with the constitution. So these restrictions that are placed on Islamic law, do they follow the three rules that follows customary law? The repugnancy to natural justice, the not being in line with any law being in force at the time being, and then the last one, which I can't really remember. But does that
apply?
follow? Yes.
Well, we cannot say that the validity test apply to Islamic law. Okay? We can't say that because in our jurisprudence, it's not made subject to it. But if an aspect of Islamic law violates other laws, especially higher laws like the Constitution of Nigeria, that Islamic law, to the extent of its inconsistency with the Constitution, will become null and void.
Okay, sir. Would you say that these laws, these higher laws that you're talking about, were made with consideration of the Islamic law in mind? Because these Islamic laws have been in place long before these new laws that we are talking about. Would you
Yes,
say that?
but we adopted the Constitution as our supreme law, so that settles it. It's just like in a community, or I understand recently that the new Aláàfin of Ọ̀yọ́, no, is it Oni now? No, it's Aláàfin of Ọ̀yọ́, right? that a new Alaafin of Oyo has been installed. That man, being the king, ceases to be ordinary man. He becomes an elder to even people that are older than him, by virtue of his selection as the Oba. Because at the end of the day, when the coronation, whatever is being done, even those who made him Oba will have to bow to him. The same thing applies to the constitution. Since it became the supreme law, number one law, all other laws are made subject to it. We take Kehinde Adigun as the last question for this class so that we can attend.
Sir, you
Yeah.
said Sharia law has its own limitation as it is. Then you explain something like the what's it called, Nigerian constitution being supreme to it. So I don't get that part. Are you saying that Nigerian constitution is one of the backbone of the Sharia law?
It is when we talk about Nigeria legislation as the most important source of Nigerian law, we are also referring to the constitution, because it is the constitution that enables other laws that we have. Every other law takes their validity. If the constitution decide to, maybe by virtue of amendment, abolish any law today, that is the end of that law, irrespective of how long it must have been in practice. Do you understand?
Yes, sir. Thanks very much, sir.
All right. So thank you very much. On that note, we bring this class to a close. I will generate my attendance from the attendance that Zoom will make available to me. So there's no need for you to send in your attendance. Thank you very much for listening and enjoy the rest of your day. Bye.
Thank you, sir.
Thank you, sir.
Bye.
Bye, sir. Bye, sir.
Thank
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you,
sir.
Thank you, sir.
Thank you, sir. Bye-bye, sir.
Thank you, sir.
Thank you, sir.
Please, have we signed attendance?
You said we should not bother signing attendance. That the Zoom has recorded it for him already.
Okay. Thank you.
Sir, there are some people that watched your class on YouTube live.
Yes, well, we'll take care of those people too.
Thank you so much, sir.
We'll take care of all of that, okay?
Yes, sir. Bye, sir. Thank you so much, sir.